Hi, welcome back to the 360 Solicitors microcast. The album is called How the Law Works in Nigeria. This is episode 6 and it's titled Nigerian Courts and Case Law. I am Ishaq, a Nigerian lawyer. You can call me Shola for short. I'll be right back. The judicial arm of government is made up of the court established for Nigeria. These courts exist in a hierarchy, and at the very top is the Supreme Court of Nigeria, followed by the Court of Appeal. Speaking of the hierarchy, the following courts are on the same level: the High Court of a State, the High Court of the FCT, the Sharia Court of Appeal of a State, the Sharia Court of Appeal of the FCT, the Customary Court of Appeal of a State, the Customary Court of Appeal of the FCT, the Federal High Court, the National Industrial Court, and the Courts Martial. Below the courts just mentioned are other courts and tribunals established by acts of the National Assembly or laws of the State Houses of Assembly, such as the Customary Court, the Area Court, the Sharia Court, the Magistrates Court, etc. The function of Nigerian courts is to resolve disputes. Wait, were we not taught the judicial arm of government interprets the law? Yes, it does when it is resolving disputes. Each of the courts mentioned earlier is created to resolve different types of disputes within their states or the federation. The National Industrial Court resolves labor or employment disputes. The Federal High Court resolves special types of disputes, such as about the revenue of the federal government, companies, trademarks, copyright, patents, banking regulation, aviation, maritime, drugs and poisons, arms and ammunition, administration and management of the federal government or any of its agencies, etc. The Court Martial is where members of the armed forces are tried for breach of service laws. If there is any dispute which any other court has no power to resolve, then the High Court of a State or the High Court of the FCT can resolve it. This is why they are referred to as courts of unlimited jurisdiction. Depending on the type of the case, appeals from the decisions of smaller courts such as magistrates courts, customary courts, area courts, Sharia courts, etc. go to the High Court, the Customary Court of Appeal, and the Sharia Court of Appeal. Decisions of the High Court, the Customary Court of Appeal, the Sharia Court of Appeal, and the National Industrial Court are appealed to the Court of Appeal, while the decisions of the Court of Appeal are appealed to the Supreme Court. The Court of Appeal, the Federal High Court, and the National Industrial Court are headquartered in the FCT Abuja, but they have branches, also known as divisions, in some other states of the Federation. The High Court of a State is also headquartered in the capital city of the state, such as Ikeja for Lagos and Ilorin for Kwara, but it has divisions in other parts of the state. Divisions are the reason why you don't have to go to the headquarters every time you want to file an action. The Chief Justice of Nigeria is the head of the Supreme Court of Nigeria and the judicial arm of government. The Court of Appeal is headed by a president. The National Industrial Court is also headed by a president. The High Court, that is the Federal High Court, the High Court of a State, and the High Court of the Federal Capital Territory are headed by their respective chief judges. The Sharia Court of Appeal of a State and the Sharia Court of Appeal of the Federal Capital Territory are headed by their respective Grand Cadis, while the Customary Court of Appeal of a State and the Customary Court of Appeal of the FCT are headed by their respective presidents. How do courts resolve disputes? To properly resolve a dispute, the judge must listen to all the disputing parties, determine the correct facts and the correct law, and then apply that law to the facts of the case. The legal principles which a court follows in arriving at a decision in a case is what is called case law or judicial precedent. No, not precedent, judicial precedent. What gives case law the force of law is that a lower court hearing a new case, for example the High Court of a State, must follow the precedent established in an earlier decision of a higher court, for example the Court of Appeal, if the circumstances of the two cases are sufficiently similar. Therefore, if the decision of Court A can be appealed to Court B, then Court A must always follow the decisions of Court B. For example, magistrate courts must always follow the decisions of the High Courts, the High Court must always follow the decisions of the Court of Appeal, and the Court of Appeal must always follow the decisions of the Supreme Court. As the name implies, the Supreme Court is final, of course not because it cannot make mistakes, but because after the Supreme Court, you cannot go anywhere else. Familiarity with case law is supposed to allow you to know what to do in certain circumstances. Judicial precedents are also why a lawyer can tell you whether you have a good case or not. However, you must know that a court setting a judicial precedent can overrule itself if it has good reasons to do so. That especially happens when there is a change in the constitution, legislation, public policy, etc. Before I go, don't forget, nothing in our podcast is legal advice. Our podcast is for educational purposes only. If you need legal advice, please consult a lawyer. If you like the episode and subscribe to the channel for more, you can follow us on Twitter, Facebook and Instagram. The handle is at 360 Solicitors or at Shola for short. See you in the next episode.